Okay, good morning. I hope everybody's having a good day. This is Howard Ehrenberg, and as you probably know, I've been a trustee for longer than I'd like to admit. It's actually going on 22 years. And frequently I get questions from people who may not have been to too many 341A hearings about what to expect and how to prepare, and so I thought I would do a webinar to give people an opportunity that they might not get at the hearing itself to ask questions. So if you have any questions, submit them through the email. I'm able to see your questions on my screen, and I'll be able to answer them directly. But I have nonetheless prepared a PowerPoint so we can at least go over the basics, and we'll start that now. So in order to prepare your client for the 341A meeting, there are a few things that I would always ask you to do. One is to remind them to bring the proper identification. The U.S. Trustee guidelines will not allow me to conclude a hearing until I see both a driver's license and a Social Security card or other form of identification that has a Social Security number printed on it and not printed on it by the debtor, him or herself. And sometimes if somebody has lost their card and they need to get a new card, it used to be easy to go to the Social Security office and get a temporary statement that has the number printed on it. Apparently they don't do that anymore, at least at our closest location. And so it's always important to make sure that they have it, because otherwise they have to come back a month later and nobody's usually very happy about that. Review the schedules in advance. I know, and you know, that debtors are often not particularly sophisticated in legal matters, but they need to understand what is in their own papers. And I do ask, have you read the papers? Did you read them before you signed them? Do you understand the information? So they should. So if I ask a question, when I get that blank stare instead of an answer, I know that maybe they had these prepared for them, maybe relatives helped them with it, but they haven't reviewed it themselves. And really they should. This is their bankruptcy case, and they ought to be able to understand what's going on. Tell me immediately if there are any errors or changes. I don't like to have to dig out the mistakes. I'd rather be told in advance. So if you are with your client and you are aware that you have discovered an error or there was a change, please just let me know right from the start what those are, and then I will get the debtor to confirm it, but at least we will not have to spend unnecessary time trying to determine where the mistakes are. I use a questionnaire. It's just a single sheet of paper. One of the primary purposes of it is I'm able to get contact information for the debtors, both an email address and a phone number. My first preference is to contact you, counsel for the debtor, but sometimes I'm not able to reach debtor's counsel, or debtor's counsel was only hired for the limited purpose of attending the 341A hearing, and I need to contact the debtor directly. And this is the best way I've come up with to get that information, since it's not otherwise included in the petition. So please have them fill out my questionnaire before I call their name. It's always sitting out on the table. And I also use the questionnaire to try and determine assets that may not be readily ascertainable from the schedules themselves. So one of the things that I look for are the sales of properties or the transfers of properties. Often there is a reason why the debtor might have sold something, such as they couldn't afford to stay in their house, so they sold it. Or they transferred a property back to a parent where the property was in their name for estate planning purposes. Those are legitimate reasons, and there's no reason not to tell me that such a transfer took place. I do look up public records for properties, and so I am likely already aware of the transfer or the sale, but it is better if the debtor will tell me about it so we can talk about it at the hearing. Trusts or inheritances, obviously most debtors don't have trusts, but debtors do have relatives, and sadly relatives pass away. And so it is the case that if someone has passed away recently, that I need to know about it, because if there is potentially an inheritance, that is an asset of the bankruptcy estate. Also, should somebody pass away in the 6 months following the filing of a bankruptcy case, that inheritance is also an asset of the bankruptcy estate. And so if somebody is aware that they have a relative who may be passing away in the near future, I don't want to sound uncaring about it, and obviously I want to be delicate, but at the same time, having filed bankruptcy, there are certain responsibilities, and that includes letting me know if there is an inheritance that is likely to be coming in. Lawsuits in which the debtor is the plaintiff. Frequently, the debtor is a plaintiff in a personal injury accident, maybe a slip and fall, maybe a car accident, maybe a work-related claim, and in most of the cases, the recovery of that lawsuit is a fully exempt asset because it's for medical bills and pain and suffering. But occasionally, the lawsuit will have other claims that can be an asset of the estate. And so what would be helpful is, if you know that the debtor is the plaintiff in a lawsuit, is to bring a copy of the complaint with you so that I can see what is in the complaint. And if there is another attorney who is handling that lawsuit, to bring me the contact information for that attorney so I can be able to reach out to that person directly. Tax refunds. Almost every debtor receives a tax refund. Even if a debtor doesn't have income, they may have the earned child credit, and that actually becomes a refund for the debtor. So early in the year, debtors often don't list that they're going to get a refund. Later in the year, I see more schedules include tax refunds. But if a debtor received a refund in the year prior, then they're likely to receive a refund in the current year. And so you should always list the potential for a refund, and then list it as an exempt asset, usually under the wild card. Money owed to the debtor. If that exists, please let me know. Usually it's in very small amounts, and I'm not going to do anything about it. Occasionally it's in a larger amount, and so I would appreciate it if that would be identified. Life insurance, as you probably know, even if a policy is a term policy, if a debtor is elderly, those policies have value and can sometimes be sold. I'm not trying to take away the life insurance of a debtor, but at the same time, if the life insurance has value, that may be something that the debtor hasn't even considered and might be beneficial both to the bankruptcy estate and to the debtor as a source of funds. So whatever life insurance policies exist, please let me know, especially if they have cash value, but also if the debtor is over 65, I may ask about it in particular. And as I said before, give me contact information. The next slide is things that I'd like you to make sure the debtor understands. Please have them be able to tell me why they filed bankruptcy. Often it's because they lost a job, they had an illness, somebody in the family passed away. Those are all perfectly legitimate reasons, but the debtor ought to be able to explain it and not have to turn to somebody else to tell them why they did this. It's that person's bankruptcy, and they ought to be able to understand what's happening to them. And too often I find debtors who can't articulate why they are there. what an exemption is. Exemption is not a word that people use in everyday language, and the concept itself is foreign. But if a debtor had options in what exemption scheme to take, for example, if there was real estate, then obviously you don't get the wildcard exemption. A debtor ought to at least have a general understanding that exemptions are assets that they get to keep, and to be able to understand why they've chosen one set of exemptions over another if that option existed for them. So I really would like that to be explained to the debtor in advance so that they can answer the question if I ask it. Student loans are not dischargeable. We won't go into any political discussions as to whether or not I think that's a good or bad thing, but in almost all cases, student loans are not dischargeable, and that can comprise a large portion of a debtor's debts, especially younger debtors. And so it ought to have been explained to them in advance that while they will be discharged from many of their debts, they won't be discharged from certain student loans. After the hearing, I may have asked for additional information at the hearing, or I may send an email as a follow-up asking for additional information. And so if I do that, obviously please gather and send me that information promptly. I will follow up, and I will sort of never forget that I've asked for information. I have a follow-up system of my own, so it's just better to gather the information and send it to my office. That will almost always result in the case then being closed because I'm simply verifying information. In rare cases, there'll be follow-up, and in the most rare cases, there'll be assets to administer. My rule of thumb, in case you're interested, is that about 2% of Chapter 7 filings have assets to be administered for the benefit of creditors. So obviously that's a very small number. Keep me informed of any changes, as we discussed before, for inheritances or other changes in the status of a debtor. If there are any changes, please let me know. Occasionally, if the debtor has a residence or a business, I may want to inspect it. I may come myself. I may send a real estate broker. I may send somebody that I call my field agent, which is someone that works in my office, to come and take a look. And if that's necessary, of course, I appreciate your and the debtor's cooperation to make that available. I will never ask to do that at night. I will always try to do that during the week, during the day. Occasionally the debtor will say it's better to do it on a weekend, and I will try my best to accommodate them. My real estate brokers are familiar with the process and will always try to treat the debtor respectfully. So please help me out by arranging those inspections. Don't destroy anything without my permission. If there's a business, there might be books and records. There might be avoidable transfers that I need to look into. There may be checking accounts that I want to take a look at. So even if the business is shut down, please do not destroy anything. If there's a computer, just keep it. If there is a computer and I ask to look at it, then either turn it over when someone comes to pick it up or bring it to my office, or I will send someone to pick it up from you. But it's very important that information not be destroyed. I'm going to be able to get it one way or another. It's just whether it's easier or harder. Also, the debtor's cooperation is an obligation, and it is in the very rare case, but if a debtor is intentionally destroying information, then that could be the cause to have a discharge revoked. I rarely ever have to do that, but it is a continuing obligation of the debtor to cooperate, provide information, and not destroy anything until the case is ready to be closed. Although infrequent, I may ask to look at jewelry or collectibles or art. Depending on the situation, I may ask you or the debtor to come to my office and leave the item with me. I will always provide a receipt for that, and I will have usually arranged for somebody who is expert with that type of personal property to look at it for me and give me a valuation. And so my goal is to keep possession of it for as short a period of time as possible. But if I do ask to see something, then please help me out by making sure that the debtor turns it over. Selling a house. Often debtors may not even be aware that there is equity in their home, although often Zillow has valuations that are high, other services have valuations that are low, and of course location and other issues may cause the house to be worth more or less than what a computer service says that it is. So if I determine that there is equity in excess of the homestead exemption, my policy is I will not simply hire a broker and put the house up for sale. I will contact you, the lawyer, first and say there is excess equity, and does the debtor wish to buy back that equity from the estate? In most cases, the debtor should be able to borrow money against the house, because not having to sell the house and pay out a homestead exemption, then the house already has equity to the extent of the homestead exemption. In other words, if it's $100,000 plus, then there ought to be a way to borrow money from a bank for the difference above the homestead exemption. What I will usually do is say, let's set a bar date for the filing of claims. As you know, often not every creditor will file a claim, and I am only required to pay off valid claims that are properly filed before the bar date. So often what will happen is the debtor may have filed a case with $60,000 of debt, but as a result of setting a bar date, maybe only $40,000 actually gets filed. That is the number that I need in order to pay claims. So I'm willing to work with the debtor if you tell me in advance that that is a process that they will agree to. In other words, we'll set a bar date, and 90 days later we'll see what the claims are, and then the debtor will agree to raise those funds in order to pay the claims and the administrative expenses so that I don't have to put the house up for sale. However, sometimes the debtor does want me to sell the house. Maybe they've had a change in their life and they can't afford the house any longer, or don't wish to stay in the house for some reason, and they filed the bankruptcy in order to stop a foreclosure, but then they want the house to be sold. Doesn't happen often, but it does happen, and if that's the case, then we will agree to hire a broker and sell the house, in which case I need the debtor's continuing cooperation to maintain the house so that it continues to show well, to maintain the landscaping if there is any, to keep the house clean on the inside, to continue to pay the mortgage and taxes. And if they do that, then I will let them remain in the house without charging them rent, because technically the house belongs to the estate, so there ought to be some value to the estate in letting the debtor stay there. It's my position that by agreeing to maintain the house in the condition it was in when the case got filed, that is sufficient value so that I don't have to charge the debtor rent for doing so. In rare cases, the debtor doesn't maintain the house, in which case I have to ask the debtor to leave, and that rarely occurs, and even more rarely occurs in difficulty in getting a debtor to move out. But that's where your help in explaining the process so that the debtor understands why I'm doing what I'm doing can be very helpful in making the process go smoothly. Overall, we all have a role to play. The debtors have the right to file bankruptcy. They need lawyers to help them with the process. There is the court and there is the trustee, and we all have a role to play. I've always believed that by treating the debtor with respect and dignity, that the process will go more smoothly. So I will always try to first take the easy approach in gathering information or in selling assets so that there's no difficulty. And so I hope that the same level of respect that I show to the debtor and to the other parties is the type of respect that I will get in return. I will tell you that I am not trying to take advantage of a debtor simply because I'm the person sitting at the head of the table. I understand that debtors and some parties don't like it when a trustee has to sell an asset, but I tell you sincerely that I am only doing what I believe I have to do. I will always listen to your reasoning as to why you think I should not, if that's the case. I'm always willing to go to the judge and get the judge to tell us what to do, and I don't take offense to the idea that a debtor may object to what I want to do and have the judge decide. That's their right, and I respect that. But I can tell you for sure that I am not trying to sell assets or obtain funds simply because I have the power to do so. My job is to simply collect what is rightfully an asset of the bankruptcy estate and distribute it to creditors. And so you may have heard me say the phrase, it is what it is. If there are assets, then there are assets. If there aren't assets, then so be it. But the process is what's important for the integrity of the system. I will always return your call or email. I am aware that there may be some of my colleagues that have from time to time not been as responsive. My office tries very hard to make sure that we respond to everybody, be it a debtor or a creditor or a lawyer. And likewise, if I reach out to the debtor or a lawyer, I would hope to get a response in a reasonable amount of time as well. So the system works better if everybody communicates with each other, and so that's what I would hope everybody would adhere to. I had hoped that this would be a bit of an open discussion, and so I would ask if anybody has any questions, that now is the time to type them in. So let's see if there are any. Okay, we do have a question. I won't embarrass the asker of the question, but the question is, when a Chapter 7 debtor is a business entity, who serves as its representatives if all officers and employees have resigned? Well, my feeling is that somebody had to sign the petition, and that person is obligated to appear at the 341A hearing. If that person refuses to, then the case may have to get dismissed, because there has to be some representative of the entity that appears. So I don't know if that's the answer you're looking for, but even when a business is shut down and there are no employees, somebody decided to file the bankruptcy case, and that person should be the one to appear. Now, sometimes that person is not the one with the most knowledge. It might have been another employee who was the controller or bookkeeper. Sometimes the accountant has the most information, and that person would still be available. But somebody needs to be able to appear at the 341A hearing, indicate that they authorize the filing of the case, and be able to answer the questions. So somebody has to be able to appear. Okay, we have another question. I have so many older clients who have student loans who cannot pay them. Do you see that in the future student loans will ever be dischargeable? Well, that's an interesting question. Of course, the statistic that I most recently saw is that student loans nationally have exceeded $1.3 trillion, which exceeds credit cards, which is very interesting because you think everybody has a credit card, but not everybody has a student loan. But student loans are often in such large amounts that the amount of student loan debt has now exceeded the amount of credit card debt. There are obviously powerful interests that do not want to see student loans be dischargeable. And there is something to be said for the idea that if somebody borrows money for school, that they ought to intend to pay it off. And it's not my belief that anybody ever borrows money or takes on credit with the intent of not paying it off. My feeling has been that the standard ought to be that the debtor be able to come to court and show a hardship, and that if the debt either cannot be repaid in full or in part, that the court can determine what amount can be paid and make that the portion that is non-dischargeable and anything else be dischargeable. But that's just my opinion. I don't hear much going on right now in the world of bankruptcy that there's any effort being made in the legislature to amend the dischargeability of student loans. So I would not expect to see that anytime soon. Now, there is still the concept of extreme hardship. And if you've got elderly debtors who are on fixed income and have no way to pay the debt, there are cases where an extreme hardship can be shown, and I would encourage you to read up on the cases and see if you can't squeeze the debtor into the rather narrow exceptions to discharge. And I think many of the judges in our district would be sympathetic to that, and so it might be worth a try. Okay, are there any other questions? If not, thanks very much for attending. I've enjoyed it. We will send a copy of the PowerPoint to anybody who would like it. We have your email from your registration, so we will send those out to you. And have a great day. Thanks a lot. Bye-bye.